We have Faith Nation team coverage of the case that brought out activists from both sides. Senior Washington correspondent Tara Merchiner is outside the Supreme Court. But we begin with senior national affairs correspondent Heather Sells with a recap on the historic argument before the justices. Heather.
Yeah, thanks, Jenna. Quite a day. The question before the court is whether Mississippi's law that bans abortion before viability is constitutional or not. Today, the justices heard from and they questioned three people: the state solicitor general arguing for the law, a lawyer for the state's one and only abortion clinic, and the U.S. Solicitor General also arguing for the clinic.
The Supreme Court is now packed with 6 conservative-leaning justices who appear poised to uphold the Mississippi law that bans abortions before viability.
Nowhere else does this court recognize a right to end a human life.
Mississippi Solicitor General Scott Stewart argued the court should get out of the business of crafting abortion policy and return it to the states.
The Constitution places its trust in the people. On hard issue after hard issue, the people make this country work. Abortion is a hard issue.
In Roe v. Wade, the court declared a right to abortion can be found within the right to privacy, stemming from the 14th Amendment. Stewart argued that abortion is not part of the Constitution.
A right to abortion is not grounded in the text, and it's grounded on abstract concepts.
What's not clear is whether the court will do away with Roe and its other groundbreaking abortion case, the 1992 KCV Planned Parenthood decision. It's why much of the arguments focused on stare decisis and whether this is the moment to break with precedent. Some of the justices worried aloud about public perception.
The newest ban that Mississippi has put in place, the 6-week ban, the Senate sponsor said, we're doing it because we have new justices on the Supreme Court. Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts?
They're going to be ready to say, no, you're just political. You're just politicians. And that's what kills us as an American institution.
Julie Rickelman with the Center for Reproductive Rights defended Roe before the court, arguing primarily for women's liberty.
For a state to take control of a woman's body and demand that she go through pregnancy and childbirth with all the physical risks and life-altering consequences that brings is a fundamental deprivation of her liberty.
Justice Sotomayor asked about poor women who suffer medical complications with unwanted pregnancies. Stewart maintained that's why the states should decide. And Justice Barrett noted women with unwanted pregnancies have the option of adoption.
Why don't the safe haven laws take care of that problem?
That would answer the reliance concern. Rickelman argued that women have come to rely on abortion and need it for success in education and work. Justice Kavanaugh pursued questions relating to what he called neutrality and said the court shouldn't be forced to pick sides.
They say that the Constitution is neutral on the question of abortion, the text and history, that the Constitution's neither pro-life nor pro-choice, but leaves the issue for the people of the states or perhaps Congress to resolve in the democratic process.
The court's conservative majority appears to want to uphold the Mississippi law, but how it will do so is unclear. Previously, the court has said that women have a right to abortion until 24 weeks or when the fetus is viable. But now the court may do away with that standard. Still, it may or may not overturn Roe entirely. A decision is expected next June or early July, just months before the midterm elections. Many believe it will be one of the biggest political issues in 2022. Jenna.